question of whether AI is patentable often leads to confusion. AI patent software is patentable, but what gets patent protection is not the code itself, rather the software performed in a computer and that provides improved performance is what may be patent eligible. So what does this mean for your role as an AI SaaS founder? We will go into details in the following discussion. As a patent attorney who's worked with numerous innovative companies, including Invisalign and Shutterfly, I've seen how proper IP protection can make or break a startup's future. Here are the crucial mistakes to avoid. First, at least talk to your inventor and scan the prior art so that way it will help you synthesize the claim, and then from there you can then collect information to explain the coverage of the claim in the description section. The second thing you need to be worried about is that early public disclosure is a silent killer of patent rights. In most parts of the world, if you discuss, show, or sell your product before filing a patent, that's a killer. In the United States, we have a 12-month grace period, but this is not true outside of the US because they follow a strict first-to-file policy. Once your invention is publicly disclosed, international rights are immediately lost. So you need to use NDAs strategically with your vendors and your employer and your contractors. For investors who are not willing to sign NDAs, you need to consider filing a full patent application or at least a provisional patent application before you discuss the technology with investors. The other thing to worry about is that you need to have a full description of how the system operates. Incomplete patent descriptions can lead to unenforceable patents. In the case of new railhead manufacturing litigation, that patent was invalidated because the provisional application failed to describe a critical feature, and thus the non-provisional application was not accorded the priority date of the provisional. Even if you're doing a provisional application, you need to provide precise description of how the invention operates and ideally provide a number of drawings and figures that explain that. Remember, picture is worth 1,000 words, so the more pictures, the better. The other mistake that SaaS founders have done is to choose the wrong patent type. Utility patent applications cover the function or how it works, while design patents cover the appearance or the ornamental aspects of the invention. In the case of software, design patents can be used to cover the UI, UX aspects, whereas the utility patents cover how the code functions and the functionality. This differs from a copyright. You disclose the code, you get the protection to that, and you can only enforce a copyright if somebody copies your code. If you take that code and patent them, you can claim the higher level function. So therefore, you have much broader protection of your invention by patenting as opposed to copywriting. Nonetheless, copywriting is appropriate if in certain cases where people copy the code and then compete against you. Another mistake is that founders think only the US and ignore global protection. It turns out that when the company grows, they might have customers in Europe, in China, and everywhere else in the world. And so if you don't protect those, you're losing out on a significant chunk of your potential revenue. And a competitor in a country that you didn't patent can certainly copy your concept. And so that's why we see in emerging countries, coders look to the popular US applications, such as, let's say, Facebook, and they just do a national version of Facebook, and they grow, and then eventually Facebook would have to pay money to acquire them. So that certainly is a strategy used in jurisdictions not protected by patent or IP rights. The other mistake is founders ignore patents or treat patents application as a low priority, and self-filing without professional eyes can lead to costly mistakes. Patent applications require a specific technical language as well as a specific way of describing the details of the invention, and sometimes even seasoned lawyers file patent applications that are subsequently denigrated by a court. So what chance would a do-it-yourself founder have in filing patent applications themselves? So have the strategy and the claims and the proper considerations for patent examination be checked by a patent professional. With that in mind, please visit Patent PC for more details. We look forward to helping you.